License and registration.
Here you go, officer.
What do you do for a living to afford a car like this?
I'm a law student. The car belongs to my father.
And what does your father do?
He's a federal judge.
This vehicle was reported stolen. Step out of the car, hands behind your back.
Officer, you should verify my ID and
Are you trying to teach me how to do my job? People like you always think.
On April 17th, 2024, at approximately 5:43 p.m., a traffic stop was initiated on Woodland Drive near the intersection of Maple Creek Boulevard in suburban Montgomery County. The stop would last 14 minutes. No citation was issued, no arrest was made, no contraband was discovered. 18 months later, the county would settle a federal civil rights lawsuit for $1.5 million. If you believe Bodycam documentation matters, that these records should remain accessible and visible, consider subscribing to ensure this work continues. This is what the camera recorded. The dashcam shows a black Mercedes-Benz G-Class traveling westbound at 6:41 p.m. Daylight is clear, visibility is unobstructed, traffic is moderate. The vehicle maintains a consistent speed. No erratic movement is observed. No traffic violation is articulated in the initial radio transmission. The patrol unit activates its lights at 6:43 p.m. The Mercedes signals right and pulls into the parking lot of a grocery plaza within 11 seconds. The vehicle stops in a well-lit area near the storefront. The engine is turned off. The driver's hands are placed on the steering wheel at 10 and 2. They remain there. The officer approaches the driver's side window. The window is already down. The driver's license, registration, and proof of insurance are held in the driver's left hand, extended toward the officer before any request is made. "Good evening, officer." The officer does not immediately respond. He examines the documents. 22 seconds pass in silence. "This your car?" "It's registered to my father. I'm insured as a driver." Another pause. The officer leans slightly forward, looking into the vehicle's interior. "What do you do for work?" This question is not standard protocol during a traffic stop. Courts have consistently ruled that inquiries unrelated to the purpose of the stop, absent reasonable suspicion of additional criminal activity, constitute an unlawful expansion of the detention. In Rodriguez v. United States, the Supreme Court held that a traffic stop may last no longer than necessary to address the infraction that warranted the stop. Unrelated questioning extends that detention and requires independent justification. The driver does not hesitate. "I'm a third-year law student. I clerk part-time for a civil litigation firm downtown." The officer straightens. His tone shifts. "Law student? In a G-Wagon? Those go for what? 120? 130? The question is not procedural. It is investigative. But there is no articulated suspicion, no observable evidence, no legal nexus between the vehicle's value and the validity of the stop. Wealth-based suspicion, particularly when directed at black drivers in luxury vehicles, has been documented in civil rights litigation for decades. The implicit reasoning, the vehicle does not match the expected profile of the driver. The presence creates cognitive dissonance. The dissonance is treated as evidence. But suspicion is not evidence, and questions about affordability do not generate probable cause. The driver's response is measured. "It's my father's vehicle. I use it when I'm home on break." "What's your father do?" "He's a federal judge." The officer does not acknowledge this. He walks back toward the patrol vehicle. The driver remains motionless, hands visible. 2 minutes and 18 seconds pass. No radio traffic is audible on the body cam. No license plate query is broadcast. No dispatch confirmation is requested. When the officer returns, his posture has changed. His hand rests near his service weapon. "Step out of the vehicle." "May I ask why?" "This vehicle was reported stolen." The statement is direct. It is declarative. It shifts the legal framework of the encounter. A traffic stop becomes a felony detention. Reasonable suspicion becomes probable cause. The Fourth Amendment threshold changes. But no evidence supports the claim. The officer has not confirmed a stolen vehicle report. He has not verified the VIN. He has not requested dispatch run a stolen vehicle check. The statement appears to justify the command, not result from verification. Standard procedure requires confirmation before escalation. The claim of a stolen vehicle triggers a heightened response: officer safety protocols, removal from the vehicle, potential search. That claim must be substantiated. It is not. The driver complies. He opens the door slowly. He steps out with his hands raised to shoulder height. He asks again, calmly, whether the officer has confirmed the vehicle is stolen. "I'm confirming it right now. Turn around, hands on the vehicle." The driver turns. He places his palms flat on the rear quarter panel. The officer pats him down. No weapons are found. No contraband is discovered. The search lasts 41 seconds. Another officer arrives on scene at 6:49 p.m. The two confer near the patrol vehicle. Their conversation is partially audible. "Run the VIN?" "Not yet. Plates came back clean, but..." "But what?" A pause. "Just feels off." Feelings are not grounds for detention. The Fourth Amendment does not permit suspicionless searches or prolonged stops based on intuition. Terry v. Ohio requires reasonable, articulable suspicion. Arizona v. Johnson reaffirms that the scope of a stop must be tailored to its justification. The VIN check is conducted at 6:51 p.m. The result is immediate. The vehicle is not stolen. It has never been reported stolen. It is registered to Judge Marcus Whitfield, United States District Court, Southern. The officer's body language changes. He approaches the driver, who is still standing beside the vehicle. "You're free to go." No apology, no explanation, no acknowledgement of the discrepancy. The driver does not move immediately. Was this vehicle actually reported stolen? There was a mix-up. What kind of mix-up? The officer does not answer. He returns to his vehicle. The second officer remains near the Mercedes, watching the driver. "Am I being detained?" "No, you're free to go." The driver gets back into the vehicle. He sits motionless for 23 seconds. Then he drives away. Language matters. Not because it reveals intent, but because it reflects pattern. During the stop, the officer made several statements that have been identified by courts and researchers as markers of implicit bias. These phrases do not require explicit racial language. They operate through tone, assumption, and framing. "People like you always think you know the law." The phrase, "people like you," functions as a categorical identifier. It groups the driver into a class. The class is not defined by behavior. The driver has been compliant throughout. It is defined by perception. When the driver cited his legal studies, the officer responded, "Are you trying to teach me my job?" This reframes the driver's assertion of rights as insubordination. It shifts the interaction from procedural to confrontational. It positions knowledge as threat. Research from the Stanford Open Policing Project and the National Registry of Exonerations has documented how discretionary language, phrases that emphasize authority over procedure, correlates with disparate treatment. The language does not cause the disparity, it reveals it. The driver remained calm. He answered questions directly. He provided identification immediately. He did not raise his voice. He complied with every command. And yet, the interaction escalated. The contrast is instructive. Compliance did not prevent escalation. Legal awareness did not de-escalate suspicion. Restraint was not rewarded with procedural respect. Behavior did not determine outcome. Perception did. At 6:52 p.m., After the driver stated his father's occupation, the officer's physical demeanor shifted. His shoulders lowered. His hand moved away from his weapon. His tone softened. "You said your father is a federal judge?" "Yes." "Which district?" "Southern District. He's been on the bench for 11 years. The second officer, standing several feet away, muttered something inaudible. The Bodycam captured only fragments. "Should have checked, and this is going to be." The first officer cleared his throat. "Look, there was some confusion. You're all set. Drive safe." The interaction ended, but the change in treatment did not occur because new evidence emerged. It occurred because status was disclosed. This presents a constitutional problem. Rights are not activated by occupation. They are not granted based on family connections. They exist independent of wealth, education, or institutional affiliation. The Fourth Amendment does not contain a carve-out for the children of judges. When enforcement behavior changes after status is revealed, it suggests that equal protection was not operative before that moment. It suggests that the constitutional floor, the baseline of respectful, lawful treatment, was not applied until external incentive appeared. This is not a matter of perception, it is a matter of record. The Bodycam documents the shift, the timestamps confirm it, the change in language is measurable. 14 months after the stop, a federal lawsuit was filed in the United States District Court for the Southern. The plaintiff, Terrence Whitfield. The defendants, Officer Daniel Kowalski, Officer Jennifer Ramirez, and Montgomery County. The complaint alleged 4 claims: unlawful detention in violation of the Fourth Amendment, unlawful search in violation of the Fourth Amendment, violation of the Equal Protection Clause of the 14th Amendment, intentional infliction of emotional distress under state tort law. The complaint detailed the sequence: the stop without articulated cause, the questioning unrelated to traffic enforcement, the claim of a stolen vehicle without verification, the prolonged detention after the VIN check, the shift in behavior after disclosure of the plaintiff's father's identity. Bodycam footage was entered as evidence, so were the dispatch logs. The logs showed no stolen vehicle report matching the Mercedes, no bolo, no alert. The officer's claim could not be substantiated by any contemporaneous record. The plaintiff sought $3 million in damages. The county moved to dismiss. The motion was denied. Discovery proceeded. Depositions were scheduled. 3 weeks before trial, the county offered a settlement, $1.5 million, paid by the county's insurance carrier. No admission of liability, no finding of wrongdoing. The officers remained employed. No disciplinary action was taken. This is standard. Municipalities settle not because they concede fault, but because litigation is expensive and outcomes are uncertain. Juries are unpredictable. Bodycam footage is persuasive. The cost of settlement is often lower than the cost of trial. The officers are insulated. Qualified immunity shields government officials from personal liability unless they violate clearly established law. The legal standard is high. The plaintiff must show not only that his rights were violated, but that the violation was obvious to a reasonable officer at the time. Courts have split on whether wealth-based questioning or pretextual stolen vehicle claims meet that threshold. Ambiguity favors the defense. The county pays. The officers do not. Taxpayers fund the settlement. The check is written from the municipal budget. No individual is financially penalized. The system absorbs the cost and continues. While the specific details of this stop are anonymized, the elements it illustrates are very real. Traffic stops without clear cause, questioning unrelated to the stated purpose, and claims of stolen vehicles that lack verification have been documented repeatedly across jurisdictions. Escalation can occur even when drivers are fully compliant, and language that signals bias without explicit racial content can influence the trajectory of an encounter. Treatment that changes based on status, perceived wealth, or occupation is not uncommon. These patterns appear in daylight, in quiet neighborhoods, with compliant drivers, and in areas without elevated crime rates. They are not rare anomalies. They are documented practices, referenced in consent decrees, Department of Justice investigations, civil rights litigation, and academic research. The Fourth Amendment exists to prevent arbitrary enforcement. Reasonable suspicion must justify a stop. Probable cause must justify a search. When these thresholds are bypassed, when a stop is extended without cause, when a search is initiated on unverified claims, or when questioning exceeds the scope of the stop, the constitutional framework is undermined. The consequences are tangible. Time is lost, dignity is compromised, and trust in law enforcement erodes. Compliance alone does not guarantee fair treatment. This is not simply an issue of individual officers acting improperly. It is systemic. Policies that allow pretextual stops, training that prioritizes officer discretion over constitutional limits, and accountability structures that shield personnel from meaningful consequences all contribute to the problem. Suspicion can be acted upon without evidence. Escalation can proceed without verification, and disparate treatment persists as long as explicit misconduct is avoided. When documentation, bodycam footage, dispatch logs, or other records contradict the official narrative, the response is often financial settlement rather than procedural reform. The stop on Woodland Drive was not about a stolen vehicle. It was about perception, about who is assumed to belong, about who is required to justify their presence before any evidence of wrongdoing exists. The driver was compliant. He was calm. He provided identification immediately. He answered questions respectfully. He asserted his rights without aggression. And he was still treated as a suspect until his father's position was disclosed. That is the record. Body cam footage documents what memory often erases. It preserves moments when official narratives diverge from reality. It creates accountability where institutions would otherwise move on. No charges were filed. No citation was issued. No contraband was found. But $1.5 million was paid. The question is not whether the stop was lawful. The settlement answered that. The question is how many stops like this end without cameras, without lawsuits, without settlements. The question is what happens when there is no federal judge in the background. The body cam stops recording at 6:57 p.m. What remains is silence, and silence in cases like this is rarely neutral.